Today's episode of Lone Star Lawyers on the Varsity Podcast Network is brought to you by Varsity Search. Varsity Search builds great teams by connecting lawyers in Texas with career opportunities at small and boutique law firms. So if you're thinking of making a move or your law firm is looking to hire, please go to varsitysearch.com and book a time to visit right into my calendar. Varsity Search, building great teams. Hey everyone, Daniel here back with you on Lone Star Lawyers. Before we get started, I want to let you know about a few of the opportunities that we are currently searching for. In Dallas, we have multiple business and commercial litigation positions, including bankruptcy, insurance defense, construction litigation. We also have real estate, both transactional and litigation, as well as a big law corporate opportunity. In Austin, we have family law and commercial and insurance litigation. In Tarrant County and Fort Worth, we have family law as well as corporate and real estate and litigation, probate, and family, kind of all wrapped in one there. In Houston, we have personal injury defense, or personal injury attorney, as well as insurance defense. And in San Antonio, commercial bankruptcy litigation as well as commercial litigation. And lastly, in Tyler, and this could be remote as well, we have IP and commercial litigation as well as a transactional position. So if any of those opportunities sound of interest to you or maybe someone you know, please get in touch with me, Daniel at varsitysearch.com. Would love to visit with you about those. All right, today we are in Fort Worth where our guest is Christian Dennie. Christian is a partner and an attorney, arbitrator, and mediator at Barlow, Garsek, and Simon. His practice focuses on sports and entertainment law clients in both transactional and litigation matters. Christian has represented sports organizations, associations, universities, athletes, coaches, agents, and more in a variety of matters in his career. He has been a Texas Super Lawyer Rising Star and a top attorney in Fort Worth by Texas Magazine every year since 2012. He also teaches sports law at both Texas A&M School of Law as well as SMU. All right, with that, let's hop into our conversation with Christian Dennie on today's Monday Mentors episode of Lone Star Lawyers. Christian Dennie joins us right now. Christian, thanks for taking time to come on the show with us.
Yeah, thanks, Daniel. Glad to be here. Good to catch up with you.
Yeah, for sure. It's been a while, and there's been a little bit that's happened, I think, in the meantime. So we've got a lot to catch up on, for sure.
Indeed we do.
Well, for now, let's start off. Christian, tell us about your practice and your firm and what all that you do.
Yeah, I'm with Barlow, Garsek, and Simon in Fort Worth. I also have a satellite office in Southlake, which is what we have here. Right now, we are a civil firm. We don't do any criminal work. My practice is primarily in sports and entertainment, but under that umbrella, sometimes catches a lot of things. I was talking to someone this morning, which means sometimes I'm a real estate lawyer, sometimes I'm a construction lawyer, sometimes I'm an employment lawyer. A little bit of this, a little bit of that. My practice started in litigation. In recent years, it's kind of crossed into a lot of transactional work, and I do a lot of arbitration work as an advocate and as an arbitrator.
Great. Well, thanks for that. And it's you mentioned the different areas that you've wound up spending time in. As we've gone over this last year and a half, it seems like almost everybody's had to become at least some level of an employment lawyer with everything going on and different things impacting the workplace and then everything else around COVID. So I think everyone's dealing with that at some level, aren't they?
Yeah, I mean, for sure, with policies and procedures relating to COVID and, some of the now mandatory vaccination issues and testing requirements. Those have been things that have really come up both in the sports world and then other areas of business as well.
Sure. Absolutely. Well, and talk also a little bit, you mentioned that you're both, the firm's headquartered in Fort Worth. You have a satellite office in Southlake as well. Talk a little about the Fort Worth legal market, perhaps for those that aren't as familiar or maybe have spent time in other parts of the state. How do you describe the bar there in Tarrant County, the Fort Worth legal market?
Yeah, Fort Worth's kind of an interesting place. It's, kind of what we call true Texas in a lot of ways. uh, but you have a lot of sophistication because there are a lot of major corporations in Tarrant County. It's still a small town that's almost 1 million people now.
Right.
So it's a little bit different environment. The bar is essentially the same. It's a lot of Fort Worth lifers, people that have been around a long time, grew up in Fort Worth, went to college in Fort Worth, live in Fort Worth, practice in Fort Worth. So it's a little bit different in that respect. Whereas, our friends down the street in Dallas with a lot of new firms coming in to town, or, bringing in a lot of people from outside of the state, which I'm not saying it's a bad thing. It's just a little bit different.
Yeah.
Between those two markets that are just down the street from each other.
And as you're talking about that, it's on my mind. I had a conversation recently with a candidate who was looking at an opportunity in Fort Worth, and they'd spent most of their time in Dallas. And we really went through a lot of the differences between the two, and how a lot of times, especially for, I think most people that have been in practice for a while know the difference, recognize the difference. But for young lawyers especially, I think it can be a misstep sometimes when they think of DFW. Oh, we always just say DFW as, they've grown up around it, and they just say that as like this describes the whole area. But when you get into legal practice in the bar, it's really not DFW. There's really two separate legal environments. It seems like.
No, it really is. I mean, in a lot of respects. I mean, in certain things it's very similar, and others it's very different.
Right.
And with Dallas being a larger market, you're going to have a little bit less connection, in my opinion, than you do on the Fort Worth side, where I think a lot of people on the Tarrant County side support one another, and in different ways. And I worked in downtown Dallas too, and I don't have any disrespect for anybody that likes that market more. It's just a tad bit different.
Yeah, absolutely. And that's what we always talk about. Just there are differences that people should just be aware of. And so I think that's helpful to know. Well, talk a little about the issues that you're seeing come up with your clients. Is there anything new and novel that you're working on, or things that they're dealing with? Obviously, we've kind of talked about COVID a little bit already, but are there any changes in the laws or procedures that are impacting your practice more directly these days? What's kind of going on and that's new for you?
Well, for me, there's been quite a bit of change with the name, image, and likeness legislation that's come on board. The most recent round of changes in the conference realignment scheme in college, and then the associated changes to the NCAA constitution have been, big changes. On the professional side that I do work in a lot as well in sports, not a whole lot has really changed substantially there. There's certainly been some big stories and some legal issues that have come up, especially recently with the release of the Washington Redskins emails, and now the investigation of the Suns owner. There's certainly been issues, but that kind of stuff is pretty, normal. I mean, I don't want to say it should be normal, but that's normal legal stuff. Nothing really novel or different to that than what it has been in the past. But certainly on the college side, there's a very different landscape and still evolving.
For sure. Yeah. And we'll dive into that in a little bit more detail here in just a minute. And I'm excited for that for sure. Okay. So when you think about your first few years in practice, when you were first getting started, what's maybe a piece of advice or something that you learned early on that has been important for you and is something that you continue to implement in the way that you practice now today?
Well, I mean, there's several lessons. I mean, the thing I tell most people, and that's fortunate for me, is have someone that will take you under their wing and serve as a mentor to you, and bring you along, put you in positions where you can learn and grow. The person that was that person for me, told me a couple of things very early on. And, one was, we win lawsuits in the library, not the courtroom.
Hmm.
So the research and dedication to the issues behind the scenes are very important. So that's one very important one. And the second was, sometimes the law is not on our side, but we have to be creative because things need to change.
Mm-hmm.
So sometimes if things don't look rosy, you can look at things through a different lens and make some changes and see some things differently, which may ultimately result in changes down the road in the law and the way things are handled.
Yeah, no, absolutely. That's great advice. I also sometimes I wonder too when you say, because I do this too, when I say talk about you said you win the cases in the library, and so working with law students now, I think about if that's the advice given like today, is that it's one on Westlaw or Lexis or whatever the new thing is that they're using to. I still looked up the pocket parts when I was in law school, which is not that long ago, but I think those are. I don't know if anyone's looking at those anymore in the library, but definitely
There's no literal library.
That's right. No.
The library's in the laptop.
The libraries in the laptop. The law schools are doing away with their actual libraries. The law firms are doing away with their actual libraries. It seems like
We did, yeah.
You did, yeah, to save that space and use it for other things. So, but I think the point being made, obviously, get the research done right and all of that. And then about making change and looking for I know you teach as well, and I do some here at Baylor on the sports law side, and we talk about for those cases especially that are 5-4 decisions, hey, from 30 years ago, 25 years ago, 20 years ago, hey, maybe it's time for that dissent to now be the majority. Like, have we evolved and changed or something different? Sometimes things need to change, and you can find smart justices that have backed your opinion and your side in the past, and maybe it's just time now, and maybe there have been changes in other circuits or things that would make it right for that. That's exciting. That can be fun, and to use your advocacy skills to make that change.
Well, I mean, and sometimes, in all fairness, it's not even just the judge making the call. Sometimes you end up settling a case, but the way the case has been handled or conducted, you've pointed out things that someone didn't consider, and they go back to the table and say, you know what? I mean, these are points that make sense.
Yeah,
we need to make some changes, one way or the other, and I mean that's good too. That's just as good as, in a lot of ways, as a court making a major landmark decision.
Well, and as we've seen across the college sports landscape and professional landscape, that just the litigation or threat of litigation can instigate changes in policy from leagues, from organizations, even if it doesn't come from a winning or a losing court case. They can definitely incentivize change, for sure. All right. So when you're working with young lawyers and associates, what's something that they can do that stands out to you and sets them apart, lets you know that they are someone to keep an eye out on and on the right track?
Well, probably the biggest thing is, taking the case and figuring it out. I remember one of the things from myself that set me apart was, when I was asked to do that research, you're given a task of looking at whatever this issue is that's outstanding, but going more than just answering the initial question, figuring out the case, understanding the case, and explaining other aspects of the case that can help the client be successful. That's probably the biggest thing. I mean, a lot of people feel like they have to sit in their office for 18 hours a day to show that they're committed. But, it's really more about smart work than hours of work. Now, I mean, some firms are going to require you to bill an ungodly amount of hours, and that's certainly a different issue.
Right.
But, when you're working a case, just because you put 10 hours down doesn't mean that you've given the client 10 hours of successful work.
Right.
And that's really what is most important.
Yeah. That's a good point. And I think that's hard for young associates who do get kind of the billable hour, expectation or goal or requirement drilled into them from that early stage. And that's the metric by which they're judged for bonuses or for salary raises or promotions and all that fun stuff. But yet at the same time, we're also told in law school that we're trained to be problem solvers and solve the problem. And that's not a time-based thing. That's did you solve the problem or not? And so how can a young lawyer juggle that or balance that or recognize that difference between putting in obviously the time that is required from the firm economic standpoint, but also like you're saying, like solve the client's problem. That's not always the same.
No, I mean, that's a good point. I mean, so there's a couple of things to that. Obviously, you're hoping as a young lawyer that you're going to work with a law firm that has enough work to where you're not having to create time,
right?
Where you're putting a sufficient amount of time that makes sense for the client based on the problem presented, to where you're not trying to figure out, well, how do I create 10 hours of work out of 3?
Right.
Because all that's going to do is present an issue that the client's not going to be so happy with when the bill comes. So
yeah,
that's an important point for young folks to understand and pick places where they can be successful in that regard. But I mean, it is a tough balancing act. I mean, I remember working in Dallas and billing a lot of hours. And then I remember other colleagues that were saying they were billing enormous hours, but I mean, they really weren't doing that.
Right. Right.
So it was, it is a very tough balance because in a lot of ways, your progression in this business is, and for some firms, is not just your success. It is how much revenue you're generating as an associate. And some associates are generating revenue that they bring in themselves to some extent. Others are 100% based on whoever they're working for to provide them with work so they can try to get to the partner level to get to clients. So it just depends on where you are and what you're trying to do as a professional. But for me, it's always going to go back to you do the right work for the client, what's actually needed, and then let the chips fall where they may on the progression.
Yeah. No, I'm really glad you mentioned that about the firm having enough work, because I mean, yeah, if you're having to stretch your time from 3 to 10 to get your hours, then that's a firm problem and a workflow problem. And, you would rather be solving 3 problems in 10 hours, 3 and 4 than solving 1 problem in 10 hours. And still that's the same number of hours for you, but just solving more problems for clients and for your firm. And so that's, again, back to, that could be a firm issue with how much work they have and do they have enough work. And then also another guest that we had, I'll have to go back and look, I'll link it up in the show notes. This had mentioned that, especially for young lawyers, recognizing that not everything is needing to take 10 hours. And so to ask the partner, like, I don't know if you have associates ask you this before, but about how much time should I, spend on this? Because, sometimes you're asking for just a quick, hey, what's the law say on this versus, no, okay, we need to write this motion. This is going to be this dispositive motion. Like that may take longer. So but for young lawyers, they may not know, okay, this can take 10 hours worth of work versus this should be just like a 1 hour. Let's just get a quick gut check on what this looks like. And so as a young lawyer asking the partner that's giving you the assignment, just trying to get a sense of, okay, what's the client going to pay for? What makes sense when we build this out can be helpful. I don't know if that's something you've run across with your associates.
No, I think that's really important to have that dialogue, not just for the lawyer and associate partner, but the client as well. I mean,
Sure.
it's one of those things where you have to understand what you're being asked to do. And, sometimes, we as lawyers that get busy and you're doing 20 different things, you've got 15 different clients you're trying to do work for on a given day. Sometimes the instructions are not as good as you think they are when they're going through your mind. So, having someone, say, do you want a memo?
Right.
Do you just want an answer to the question? Do you want a case? How are we going to do this? A lot of times what I try to tell people is if it's a motion, we're doing research for a motion, draft it in a way where we can just drop it into the motion.
Yeah.
We don't need if this, if that, if this, if that, if this, if that, if we're trying to answer a very specific question that's being posed or an argument that's being posed. So let's draft it accordingly so we don't have to redraft it and charge the client to do the same work twice.
Yeah, no, absolutely. How would you advise an associate who's still in those first few years of practice to start thinking about developing their own business, or should they be thinking about that in those early stages? What's something that, thinking about developing a client base or potential, as they're looking ahead, maybe to either become partner at the firm they're at, or maybe they want to open their own firm at some point. Are there specifics that you would advise them at the early stages of their career to be starting to do?
I mean, honestly, I advise my students that are still in school to start developing the game plan before you get out of school.
Yeah.
You can't have a client while you're in law school, of course, but you can have a plan. You can start developing ideas on how you're going to generate the type of clients you want. And of course, in my space, in sports and entertainment, and if you want to be representing athletes and you don't know any athletes, you're either going to have to get to a level to where you're phenomenal at whatever it is you do, or you're going to have to be you're going to have to be in places where they are, or their agents are, or their financial advisors are, or whoever you're trying to represent. So you can develop a game plan to join certain organizations, to be around certain people, start meeting people early on, even while you're in school.
Yeah.
Start developing the relationships. Now, I mean, realistically, people that are ahead of the curve, maybe they're 2 years, 3 years out, that they have enough of a grasp to really help clients. Most people, it may be 5 to 7 years before, some 10, before you have that grasp. It just depends on the individual, but it's never too early to start trying to develop what you're doing. Because I mean, it may be you want to be a sports entertainment lawyer, but the job you can get is in real estate. So if that's the case, obviously you want to get really good at real estate. But if you're saying, I want to do entertainment contracts, well, you're going to have to go find entertainment contracts and get to a point to where if you do get that meeting with the entertainer, that you can say, look, these are the type of things that are going to be presented. These are the arguments we're going to have to counter it. And you can be well versed in that when you have that opportunity.
Yeah, no, I think that's a great example. And I think those all tie so nicely together. And I think about and advising students as well, especially getting into any like super niche or challenging area to get into, sports entertainment law being one of them, which is, to your point, a lot of times, especially for a new lawyer, I mean, that's just not realistic to get a law firm job doing sports law or entertainment law. It's just probably not going to happen right away. But like you said, you get a job in real estate law. Well, I mean, athletes buy real estate. Entertainers buy real estate. They have real estate brokers. There are places to take, like you said, get really good at real estate law and then place yourself where you can be potentially interacting with those clients at the level that you're an expert at now in real estate. And then from there, maybe it can morph into other types of representation, types of work, things like that. You probably, I feel like I know one of the other places where you probably do some of this work too, but where people that represent athletes are also doing a lot of nonprofit work to set up the nonprofit entities that the athletes and coaches want to use to give back to their communities, give back to their families and schools and all that fun stuff. And so there can be ways to access it that direction as well. So, there's a lot of different ways to get places, but having the plan, like you said, starting early, getting that plan together, and not just having it try to, happen with, serendipity is definitely a better way to approach it. It seems like.
I mean, a lot of it is really, representing an athlete in, as an agent's one thing, but, on my side of the table as the lawyer for these people, it's really understanding the culture.
Yeah.
It's, it may be a real estate transaction or setting up an entity or a trust or whatever for the athlete, but it's the comfort level that they have with you because you understand the game, so to speak.
Yeah.
That's really what it is. I mean, like I said before, this morning, a client calls me interested in having a baseball facility. So I make a phone call on that. And, that's really just a real estate deal.
Yep.
With a client that happens to be in baseball.
Right.
But because I understand baseball and that culture, that's an easy transition on over to the real estate piece.
Yeah. Yeah. No, absolutely. All right. Last question before we do a little bit of sports law stuff specifically. When you're hiring people, when you're hiring associates, and I'm thinking now mostly about, people that have been out for maybe a couple of years, 3 years, and they're, lateraling from another firm. What are some key things that you're looking for either in the resume or in an interview? What are the things that stand out for you that are important?
I mean, well, there's several things. I mean, one, we want to make sure the folks have done well in school, that they committed to that. But, that's kind of a baseline deal.
Right.
If you've been out for a couple of years, I mean, really, it's going to be what kind of work have you done? Yep. And what kind of work product have you developed? Do you have any kind of name for yourself at all at this point, which is not necessarily a deal breaker because a lot of associates are grinding 2 or 3 years out. They're not out in the public yet, but, trying to find, things like that. How does their work history balance with what we're after? But then it really comes down to, is there a cultural fit? Me, myself, I get a lot of calls, primarily because I teach, asking questions and things like that. I mean, former ball players, I'm going to help those people out because I was in their shoes.
Yeah.
So I mean, that's something for me that, that jumps out, of course. I mean, sure. I think being a competitive athlete at the college or professional level shows a level of grit that some people like.
Yeah.
Me included. But, so I mean, there's certainly other things. I mean, if you've published something, that's something that's good for sure. I mean, if you've been a federal clerk, Supreme Court clerk, something like that. I mean, obviously those things are good. Trial experience, if you've actually gone to trial in an era where you rarely go to trial,
right.
That's a good deal. If you've closed certain real estate deals of a certain value and you know how to walk through that transaction, that's great. If you've done employment contracts and you can say, look, I mean, I've done 100 employment contracts in these industries, those are all good things. So it's really comes down to, are you a cultural fit and have you done the work, or at least have a level of interest where you can easily cross over and do the type of work we're trying to do.
Yeah. Yeah, no, definitely. And And as we've been talking about over the last few weeks, when we were talking about resumes, is just the importance of being able to communicate those things through a resume that you have done. And that takes some effort. That takes some real thought to all the things that you just mentioned. If someone's done those things, well, they've got to be able to communicate that to you through a resume, at least at an initial level. So we've talked about that in some previous episodes, so I won't go into it now, but just something to be thinking about. All right. So let's take just a couple minutes and talk about some of the sports law topics of the day. You mentioned earlier name, image, and likeness. We've been under the new NIL rules here in Texas and other states around the country with their own laws since July. Most of us. What have you seen in practice now? That's actually we've had all the build up and all the hyperbole and all the stuff up and until July. And then now we've actually had some deals happen and some things happen. And but what are you seeing on the ground here with name, image, likeness with college athletes?
Yeah, so there's a lot. So I mean, the first thing is Dr. Pepper had the one deal with the quarterback from Clemson, but there's not a lot of big national deals yet.
Yep.
We'll see how that shakes out, especially with the Gatto criminal investigation and ultimate findings up through the Second Court of Appeals or Second Circuit Court of Appeals. You thought based on that stuff that the shoe companies would jump in. They haven't really done that yet.
Mm-hmm.
So it's a lot of regional and local deals for the athletes. Some of the big things are trying to make sure they comply with state law, because if the agreements don't comply with state law, then they don't comply with NCAA legislation, which is an eligibility issue. One of the big things in Texas is the contract can't extend beyond your intercollegiate athletics eligibility. So if there's a perpetual license, that would conflict with that statutory provision, which that's one of the things that's interesting. As I've seen in some of these deals, people are throwing the perpetual license in sections that you would not expect it to be in. Seen it thrown in the works of authorship sections of contracts and other places. So you've got to actually go and read all the words and search it down.
Right.
There's just a lot of moving parts to them. A lot of sponsors initially were saying, hey, I'll give you a bonus if you achieve these results. That's not permissible under the state law.
Right.
There's just a lot of things that are, starting to be ferreted out now that it's been around for a little bit, and the schools are getting a better grasp of it as they've seen more deals and they're educating more and things of that nature. So there's still a lot to be learned, but other than a couple of requirements in the statute, it's still just a general sponsorship deal.
Yeah. What about the, at least in Texas, right, the restriction on the use of the school's logos and images and marks and that type of thing? And I'll just related question to that, because I think they're linked, if I understand correctly, but because it looks like there have been some ways, at least maybe in other states, maybe here too, where there have been some workarounds when it comes to using group licenses as a way to counteract that in some ways. What are you seeing on the use of the logos and marks, and then also individual deals versus potentially group deals, either team wide or athletic department wide?
Yeah, I haven't myself done a group deal for athletes. I have reviewed some of the group deals for athletes, but I haven't put one together myself, so I don't have necessarily personal knowledge on that end. The use of logos and marks is important because not every state has the regulation that says specifically you can't use them.
Right.
Now, you could be in a set of circumstances where the sponsor also has a deal with the institution, and then you could use them.
Mm-hmm.
But there's a lot of weird components to that, especially in the Fifth Circuit with that Smack Apparel case where LSU challenged the use of their colors and after they won the national championship, which would throw some wrenches into that. And I know some of the schools are trying to figure out the best ways to to allow the use.
Yeah, right.
And how they can license their marks for that purpose, because you could have essentially a double benefit there.
Mm-hmm.
So I mean that's a big deal, but I mean that's really not much different than what we see in other deals. I mean, like what I always remember as a kid is you get the baseball cards out of the cereal box and the players don't ever have any of the logos on their hats. They strip those off. Well, because they didn't have a licensing deal with the teams.
Right.
They had a deal with the Players Association, but not the teams.
Yeah.
So, I mean, that's not really a new deal per se. I mean, we've seen that for a long time. It's just the fact the statute specifically says it.
Right. Yeah. Yeah.
I don't think that was necessary.
No, sure. It doesn't seem like it. But that's interesting. Well, and then the other thing I wanted to ask you about that's kind of a not sports related, more entertainment related, but we've seen this at different points in time, and that is and it's been on my mind lately. The concert in Houston with the trampling of the people and people passing out, people dying, people injured, all of that. As an entertainment lawyer and a sports lawyer, what are the things that are going through your mind as you're seeing things like that play out? Obviously, we have situations that can get that way at times with end of game storming of the field issues. I'm not aware of having anything as significant as what we saw in Houston. I mean, that's sort of next level, but it sort of helps shine a spotlight in some ways on this issue and topic. But I'm just wondering, when you observe that, when you read about what happened, what are some of the issues that you're going through and things that you're thinking about?
Well, I mean, the first couple of thoughts, I mean, is obviously the liability questions that you're thinking about, which really come down to several different things. One, did we have adequate security?
Right.
At the event? Did the security do their job? Did we hire the right folks? So, I mean, that's kind of one thing. And then two, what does the license and waiver on the ticket say? And do we have an enforceable arbitration clause?
Yeah.
So those are some big things. There was some case law that came out, I believe that was earlier this year, talking about the licenses and the waiver language on the ticket, and whether having another link that you can click, because everything's done digitally now, another link that you have to click on to go to the arbitration provision, and whether that was an adequate arbitration clause. And in one case, they said it was not. So, those are the kind of issues that you're really thinking about from a legal perspective. Obviously, from a moral and just human perspective, I mean, you hate to see all that stuff happen, but, somebody is going to sue the venue. And in that case, somebody will probably sue Travis Scott as well. His management team and the production and whoever else was involved in that event, which, all of those people are going to have to pull out those contracts and see who is indemnifying who and who released what and what waiver was there for this, that, or the other thing. So, I mean, there's a lot of, and making sure you have insurance on those issues, which, entertainers like that, they have, tour insurance for sure. So, there are going to be a lot of different issues there to roll back to see who has what liability, if any. So a lot of things to think about.
For sure. Gosh, it's just tragic and hard to think about and watch. But all right. Anything sports law on the top of your mind, or something that is taking up a lot of your time, or that you're thinking about before we finish up here with our rapid fire questions, because we're running out of time for you. I don't want to take more of your time.
Yeah, I mean, the big thing is going to be this that just came out a couple of days ago, is the NCAA's recommendation on constitutional issues and their bylaws, and there's actual Constitution itself. And, how that plays out. I mean, obviously basing off of the the concurring opinion in the Alston case, saying the regulation at the conference level would be permissible, which is, generally how it's been in all kinds of businesses, especially in antitrust cases that have caused breakups in the past. To see how that plays out, what is the NCAA's role moving forward? I mean, you would hate to see a circumstance where there's no NCAA men's and women's March Madness. I mean, you'd hate to see a circumstance where of an event like that, or a College World Series, events like that are of a different animal at some point. That would be unfortunate for the fan, but we'll see how that continues to go, and how the conferences get along, and that if the NCAA is not there and it's run exclusively at the conference level, which I don't think that'll be the case, but if that ends up being the situation, all those conferences are going to ultimately have to come to a set of agreements on how these events are going to be run.
Right.
And at some point, there will be some requirements that the schools meet a certain set of rules, and it ended up being similar to what the NCAA is anyway, most likely. But
there's
a lot of different things to look at on that front for sure.
Yeah, no, I think you're right. Replace that NCAA manual cover and have some other title on it and move on with whatever the new thing is, pretty much.
Yeah, I don't think that'll happen, but
no.
I know a lot of people are making the argument that there should be a nuclear option.
Right. Yeah. Well, a lot to digest and see what happens next. But all right, so rapid fire questions to finish up here. If you're ready, we'll jump into those.
Sure.
All right. All right. Name the one trait or characteristic that you most want to see in an associate.
I think it's just, ability to roll up the sleeves and get after it. Understanding that no task should be looked upon as, well, I'm a law school graduate, I don't need to do that. If you're called on to send, a fax, as archaic as that is, go send the fax, but roll up your sleeves, get after it, try to get the best results you can for the client. Yeah.
And that's FAX to the young listeners, not FACTS that he was talking about.
Facsimile.
That's right. What habit has been key to your success?
I would say it's probably just trying to understand the client specifically in those relationships. So, which really goes back to the word trust. When you're developing those relationships and the client trusts you when they have an issue to make the phone call.
Yeah. Your favorite app or productivity tool?
I do use a lot of apps, but for productivity, I don't know.
Now, what's your favorite app? You can go with that.
Probably Twitter, just because Twitter's my favorite because, you follow the right people, and whatever issues I need to follow, I can just go there and get on it pretty quick.
For sure. No, absolutely. All right. What would you list first on the interests section of your resume?
I'd probably be, if I was being generic, sports is probably going to be the first. If I'm, being accurate on time spent, it would be family.
Yeah.
But, to the extent I get to have hobbies anymore.
Right. I know it. It's hard these days.
Stand-up paddleboarding, that's fun.
Oh, there you go. Yeah, for sure. Man, I tried that in the ocean this summer, and I'd never done it before, even on like still water, like on a lake or anything like that. So first experience is on waves. That did not go well.
Where'd you go?
We were on the just on the Florida coast and like the Gulf, down there. And it was our first time there. It was great, but not the best first place to try stand-up paddleboarding, I don't think. Although if I would have gotten it there, maybe I'd probably do it anywhere. But it was interesting.
Yeah, no, it's fun. I've done it on, lake, river, ocean.
Yeah,
it's a good time for sure.
It is. It was fun. All right. I do actually have one more. I'll ask this first. No. We'll do this one first. Okay, your favorite legal movie?
Favorite legal movie? Yeah, it's probably either Time to Kill or something like My Cousin Vinny or something
Yeah.
like that. Yeah.
Those are both great.
Yeah.
For sure. My Cousin Vinny is probably the most popular answer, I think.
Is it really?
Yeah. For sure. Time to Kill, though, we've heard a couple of times lately. So yeah, that's a good one.
Yeah.
Awesome. Okay, so the one that I didn't have on the notes ahead of time, but this is a good rapid fire question to end on for you. What year does Oklahoma and Texas play in the SEC for the first time?
I say 2023.
Okay, I think that's a good safe bet. Yeah, 2023. Yeah. All right. Well, I won't ask you how much they're gonna have to pay to do that either. So we'll leave that. We'll leave that one for another day.
A lot of American dollars.
A lot of American dollars. All right, Christian. Thanks so much for coming on the show, man. It's good to catch up. I appreciate it, and wish you and your firm all the best.
Yeah, man. Appreciate you having me on. Enjoyed it.
All right, my thanks again to Christian Dennie for joining us on the show today. If you enjoyed this episode, would you do two things for me? Would you subscribe so you don't miss an episode? Then would you rate and review the podcast in Apple Podcasts or wherever you listen? And if you have suggestions about the show or if I could help you in any way, please email me, daniel@varsitysearch.com. Likewise, if you are interested in any of the opportunities that we mentioned at the top of the show or just want to visit about the legal market or what might be out there for you, please get in touch with me. I would love to visit with you. All right, that's it for today's episode of Lone Star Lawyers. Thanks again so much to each of you for listening. I'm Daniel Hare with Varsity Search, and we'll talk with you next time.